My name's Kate Merlin. I'm an attorney here in Colorado. I got an LLM in natural resources law from CU in 2013. I've been working on oil and gas issues sort of ever since. I'm one of the attorneys on the Martinez case, and I'm involved with some of the Broomfield litigation. I've worked with Matt. Thank you. I've worked with Matt, sir. I've worked with Dan Leftwich on the Martinez case, as well as some of the Broomfield litigation, and I've worked with Mike as well. So sort of everyone here is kind of a rock star. I'm very happy to be facilitating this panel. Dan's going to be the next presenter, talking about preemption principles and the way that the state and industry collude basically to coerce people into having to basically fight over scraps and crumbs instead of getting the protections that they deserve. Is that correct?
Sounds right. My name's Dan Leftwich, and so my talk is about the Martinez standard and your rights and the precautionary principle. And so the scientific panel that we had up here earlier this morning talked a lot about, data and studies and limitations to studies and what constitutes safe practices. How do you judge whether something is safe? And to me, that involves when you should use the precautionary principle, and we'll talk a little bit about that. By way of background, I have about 25 plus years of experience in complex litigation. I used to own a firm in Washington, D.C., a law firm that took on a lot of class action antitrust work, monopolization cases, price fixing against Fortune 100 corporations. So getting at the how to address corporate power, right? So in 2003, moved to Boulder in order to get out of the insanity of Washington, D.C. And then 2009, after a period where I'd been looking at the effects of climate change and the environmental issues, came across Father Thomas Berry's work, which led me to start my own firm, Mind Drive Legal Services, and helped co-found Boulder Rights of Nature. And so the rights of nature, legal rights of nature, are important part of my work, right? And earth jurisprudence, you might call it. Then I started getting lots of calls from people along the Front Range wanting to know, what do I do about this fracking operation that in Weld County that is coming close to my house, and and I'm having all these serious health effects. And so because I used to be a class action antitrust lawyer, a contingent fee lawyer, I guess people thought, well, maybe you can help me. So I started looking at the issues in great detail, not just the impact issues, but what are the legal issues? What are the underpinnings of this problem, right? And so we're going to talk about the precautionary principle, because this is the battle, right? This is the battle over who has the burden, right, of showing this is safe or this is unsafe, right? So the precautionary principle is pretty simple. When an activity raises threats of serious harm to human health, threats of serious harm, the environment or wildlife, preventive measures should be taken, even if some cause and effect, causation issues, are not fully understood or established. Now, I am co-counsel with Kate Merlin. I'm going to step over here so I can see this. In the Martinez case, which some of you may have heard about. It's currently pending before the Colorado Supreme Court, awaiting a ruling. It started with a group of teenagers, Earth Guardians, right, who went to the COGCC, filed a petition for rulemaking, asking the COGCC to stop permitting until they could demonstrate that their permitting processes protected public health, safety, and the environment, and did not contribute to climate change. And presented lots of evidence, lost at the agency level. The agency decided not to initiate the rulemaking, but as part of that process, the chief legal director for the CDPHE was asked by the agency for an opinion about, okay, what all these studies that have been presented by this group of teenagers, you know, what's your opinion about whether they show that this is unsafe and we need to initiate this rulemaking? So the CDPHE issues a letter opinion that says, because you, the teenagers, haven't shown unequivocally that all these studies demonstrate that human health and the environment are adversely impacted by fracking, the agency should just go ahead with its permitting. Okay, so that's why the precautionary principle is important, because they flipped the burden on its head, all right? And they said, no, you have the burden of showing unequivocally. That's like in a criminal case. You have to show beyond a reasonable doubt, all right? Well, that's not anywhere near the standard that should be applied, okay? It should be that the industry is responsible for this harm. They should have to show that their processes are safe, all right? Now, so that case is pending before the Colorado Supreme Court because, now I have this question. Does anyone in this audience think that fracking is safe for neighborhoods? We're talking about 56 well mega complexes right now. I'm assuming the answer is no, okay? And 1.1 million voters just said it's not. That's Proposition 112. Even though it lost, that's a heck of a lot of people, okay? That sends a resounding message to the politicians, to the industry, that the setbacks that were changed in 2013, it was totally arbitrary, okay? It was a political decision. They said, oh, well, these environmental groups, they want, you know, 1,500, 2,000 feet setbacks. The industry wants 350 to keep what it is. So they picked a number, right? They picked a number in between, and they admit that they did, right? And they didn't even include the cause and effect of air pollution from these sites when they decided how to set their setbacks. So it's not safe, so why do we allow it to ruin our communities? This is why, okay? Now, I call it the fracking racket. Maybe you can come up with your own term, right? But these are the pillars of coercion, I call it, okay? These are the points at which communities would like to make a different decision, but they cannot, because the industry has coercion over them, has coercion over city governments, and can force them to do things that no sane, rational person would do, right? So the first and foremost pillar of coercion is preemption. It's state preemption of local laws. And so a little bit of history, 2012, communities like Longmont, Fort Collins, and Lafayette, and Broomfield kind of broke out of prison there for a little while, right? And it was a jailbreak, right? And so they passed initiatives saying we need to ban fracking in our community, or we want a moratorium in fracking in our community, or you know, some variation of that, right? And so the industry used state preemption over those communities in order to put them back in prison. Now, in the meantime, while the case, the Longmont case and the Fort Collins case, was winding its way up to the Supreme Court, the industry knew it had a problem. Preemption might not be the fail-safe for them, right? So they started doing this, MOUs and vested rights. Now, what are MOUs? You're probably all familiar with them now, memorandums of understanding, right? Now they're called operator agreements, where they're negotiated between the city and the operator, and in order to basically say, look at all these, what they're calling best management practices that we're putting in this operator agreement, right? Those were initially designed by the industry in order to take pressure off of the state, because remember, the state came in and sued Longmont. The governor authorized a suit against his own citizens in Longmont, right? Big problem with that. And so the industry said, we'll take some of that pressure off of you. We'll start putting this into negotiated agreements. And we'll even go beyond what the COGCC requires. We'll show that, look, we're going way beyond. And so you can tell your citizens, then you're doing the best that you can. Because if you go beyond that, preemption comes back in, right? Now, invested rights are something that we're finding is their point of coercion, where they say they negotiate this agreement, this MOU or this operating agreement, and they get it in place, and then they say, if you try to come back later with a new law or an initiative, like Broomfield's 301 amendment, then we have vested rights in this agreement that can't be overcome by your new law or your new initiative, okay? So that's what we're facing in, Kate and I are representing a group called Residents' Rights and Wild Earth Guardians in a suit against the city of Broomfield and the city manager of Broomfield, all right? And in part, it's about the interaction between their MOU, which they rushed the city council, and I don't want to paint with too broad a brush. I know Councilman Krieger's here, and I appreciate that not all council people are the same, all right? Thank you. Yes. But what they did was they rushed it through just 2 weeks before the vote on Amendment 301 in order to get vested rights. Now, we're dealing with that in this lawsuit. I can tell you right now, no ego involved. I've cracked the code, okay? I understand vested rights. They do not have vested rights. Vested rights can never overcome the right of local governments or the rights of citizens to pass laws to protect the public health and safety, okay? That's a fact, all right? And the Colorado Supreme Court has said so many times, right? But they use this as marketing, okay? So Dr. Merlin said they try to divide and conquer. They try to say, oh, look what all that we're doing in this MOU. And then the city says, well, we can't do more. Our hands are tied, right? Now, the other points of coercion are forced access to open space. And you asked about why are they moving into Boulder County and trying to use their infrastructure, you know, $400 million worth of open space, okay? It's because there's fewer and fewer large plots of land available to them where they have to consolidate these operations into larger and larger single operations, okay, because of their cost structure. The economics of fracking have gone from bad to worse, and so they're going to use your open space, right? Force access to it, and then force pooling of mineral rights, okay? And we are going to challenge all of these, all right? We have to challenge all of these. Because fracking cannot survive without coercion, okay? Just can't. Now, this is the law. This is the Martinez opinion, the basic opinion, right? It says basically that development of oil and gas must be regulated subject to the protection of public health, safety, and the environment, all right? Now, the COGCC has ignored it. It flat out ignored it. And it's a published decision. That means it's binding precedent on all lower courts in the state, right? Even though it's on appeal at the Supreme Court, the agency didn't ask for a stay of the Court of Appeals opinion. They just decided they'd ignore it, okay? Now, this is what their approach over the last 10 years or so has gotten us, all right? This is the explosion at the extraction pad outside of Windsor. Now, Instar, researchers at Instar taking measurement levels at Boulder Reservoir 40 miles away, saw huge spikes in benzene and other VOCs, right? Now, this is what's happened since the Martinez ruling, okay? COGCC's approved 6,534 drilling permits. Another 6,598 are pending, and that was as of yesterday. 391 location permits are pending. Okay, this is reckless. Honestly, it's reckless. And I have a message for Governor-elect Polis, okay? Now, I'm not prone to hyperbole, okay? We have to demand a moratorium immediately. Now, this is not, I'm not, before the Denver Post and everybody else, in the industry says, oh, he's just asking for a ban on the industry. I'm not. This is rational public policy, okay? The prior slide, this is what happens when you don't put a moratorium in place. When policy is uncertain, you don't know what's going to happen with Proposition 112. They didn't know what was going to happen with the Martinez decision. So this is what happens. They all rush in, get their permits in. The agency starts rubber stamping them, right? And so you have to have a moratorium. That's the only rational thing to do. Now, the governor can do it. He's the chief executive. This is an executive branch agency, all right? Now, so what should be the goal? And I'm going to wrap it up, all right? The goal should be legislative, legal, and when I say legislative, I mean the people's right to legislate as well, okay? The citizens' right of initiative, that's your right to legislate. So the goal should be to remove the ceiling of protection on protection and restore the floor of protection, okay? Now the ceiling on protection, that's preemption. The agency says you can only go so far to protect your own health and safety. If you go beyond that, we're going to preempt it, right? And the Longmont and Fort Collins decisions, those were the judicial ceiling of preemption, right? The floor of protection, the Martinez case, restored the floor. That's all it did. It just said there's a floor of protection, okay? Basically, regulation has to be to protect the public health and safety. If it's not, the development can't occur. That just restores the floor because the agency had removed the floor, right? Their balancing approach said, okay, we don't have to actually protect public health and safety. We get to balance it against economic interests, the fracking interests, mineral rights owners, everybody else, right? So that's a total disaster. Imposing a ceiling and removing the floor. That's death, okay? Honestly, literally, it's death. That's Firestone, okay? And so whatever we do from a legislative standpoint, it has to be focused on restoring the floor of protection and removing the ceiling. So if Boulder County or other jurisdictions want to do more to protect their public health and safety, they can do it, actually, right? And you restore the floor so that even though Weld County doesn't care much about public health and safety, they'll have legal problems if they don't, okay? But you have to restore it in a legal sense, okay? Now, the COGCC is a lawless agency, and I said I'm not prone to hyperbole. This is just a fact, okay? They have been ignoring the law for a year and a half, and for a long time. Their balancing approach has been ignoring the law, all right? The legislature has told them over and over again, change the law, change the law, change the law, and said more and more protections for public health and safety are needed, and the agency then goes into the bowels of their rulemakings and undoes it, right? Grants themselves rights to variances for virtually any rule. Now, so they all have to go because they've just been lawless, right? And we need a rapid transition from fossil fuels. I mean, everybody anybody who's seen the climate change reports that are coming out, this is imperative, all right? And so basically, if the state won't protect the public, local governments have the right and the power to do so, but we have to restore that right. And if local governments won't protect the public has a right to protect themselves, okay? And so that's what I want to say.
I asked how many cases have been filed for those approved APDs that were in violation of the Martinez standard?
There's a number of suits that have been filed against, for example, in the Bella Romero case and Triple Creek in Greeley. And so there's a number of suits that have been filed against the COGCC over their permit approvals. The case that Kate and I are involved in Broomfield is a suit against the city, right? Because they also are supposed to have approval authority over permits, right? And so the argument that those permit approvals violate the Martinez standard is involved in probably 4 or 5 cases. A couple of them are already at the Court of Appeals. And so it's being litigated right now. One district court in Denver flat out ignored the Martinez opinion. I can't be any clearer about it than that. The others were on more technical grounds that it didn't violate the COGCC's rules or whatever. But the issues are currently before the Colorado Court of Appeals on that. And I think the Court of Appeals is probably waiting for the Supreme Court to make a decision. Right?
Okay, thank you. I guess one more question.
So if the Martinez ruling is the law of the land, how are they ignoring the law right now and permitting all of these wells?
There's special brand of magic.
They're claiming that the ruling only went to whether they had to initiate the rulemaking in the original case, despite the fact that the Court of Appeals said this applies to all decisions that the agency makes in regulating oil and gas, all right? So they're just ignoring it. They're just treating it like it doesn't.
They're not ignoring it, though. They're violating it, right? They're violating the law.
Violating it.
So whose job is it to hold them accountable for that?
That's where we're trying to do that through various legal means, right?
We're doing it now.
The governor and the...
Well, yes, the governor is the chief executive, right? This is an executive branch agency. The governor could say to the agency, no, you have to comply with the Court of Appeals opinion.
So that's what I guess Mike is about to talk about. Mike, I'll let you introduce yourself.
Mike Chiropolos, and I've been kicking around on these issues for a couple of decades, I guess. And my sense on Martinez, so Matt was still a law student. We worked on the statutory reforms in 2007 after Governor Ritter was elected. I helped draft and pass the Colorado Wildlife Habitat Stewardship Act. Matt was the lead on 1341 COGCC reform. My take would be that the Martinez ruling got it right because we said, damn it, you need to be able to protect public health and safety, and that's paramount. It's discretionary, though. It doesn't require them. So Ritter wasn't around long enough to give it flesh, to give it meaning. Hickenlooper wasn't interested. We heard from a governor this morning who agrees with those of us in this room because he's experienced it. He's lived in a community that's experienced it. And now is the time. We got to figure out what reforms and what further legal changes. I think we're on the same page and we're working for the reform we need. I've got 3 big picture things here. If I can figure out how to move this thing. Colorado is poised to make history. Make history as a national model, leading the way to a clean energy economy for the region, the nation, and the frickin' planet, all right? It's the people in this room who are going to make it happen, all right? We've got that governor we heard from this morning. We've got citizens like Joe who just showed up. And don't get me wrong, strong women legislators in positions of power. Tammy, Edie, Casey, Sonia, and Emily just got elected. Moms and women who get it, who care. That's going to make a big damn difference, okay? The outgoing governor, he's a decent man. I really like him personally. He considers oil and gas property rights, the mineral subsurface, an absolute right. I would say I'm a little more moderate than Dan in some respects. All we lawyers, we come out differently, but the current governor came up as what? An oil and gas geologist. Before he was brewing great beer, he's been getting bad legal advice from ignorant or self-interested attorneys who don't want us to channel this fundamental model that oil and gas property rights are absolute. All right? I came up as an organizer like Matt with Western Colorado Congress, federal issues. I worked for Indian tribes for 10 years, tribal issues. I've worked with local government. Let's walk it through. Can you drill? Can you lease and drill in Rocky Mountain National Park? For crying out loud. Indian Peaks Wilderness Area. Areas that aren't closed down by federal law. Garfield County, Colorado, Piceance Basin. Let's talk Roan Plateau. Let's talk Thompson Divide, where I represented the town of Carbondale for 10 years. Areas not allowed. Let's look at the biggest oil and gas state in the frickin' lower 48. That would be the Cowboy State, the Centennial State, my friends. Wyoming. The Shoshone National Forest has 92% of its acreage closed to oil and gas development, more than the White River National Forest, which is in the top 5 in the nation, the most visited recreational forest. Wind River Indian Reservation, where I was proud to represent the Eastern Shoshone tribe for several years. We shut oil and gas down, an oil and gas tribe that depends on the revenues. The roadless area was off limits, and other areas, Fort Washakie, Ethity, where people lived and constituents were directly affecting the tribal council, areas were off limits, okay? So I want to talk about what I see starting from a clean slate, what we can be doing. And there's a lot of great issues, but we need to chip away at this idea that oil and gas is an absolute property right. Dan, I'm going to say the more rights are out there, once it gets leased and you've got permits approved, it's a little bit trickier legally, just to say it delicately. It doesn't mean it can't be done because we've done it. We've done away with leases and that sort of thing. But opportunity has knocked. This is my big spiel. I've got the contact Sarah myself. If you want the whole speech, I've got a 2-pager and a 6-pager. All right? But we're doing 3 things. And the solution is the transition to this clean energy, livable climate future. Chiropolos gets that, and he knows that's the platform to get elected. It's talking about the future, and guess what? I've been telling my kids since I was doing this work and they were young, they're going to be drilling Yellowstone and Grand Canyon when you guys are my age if we keep burning this stuff the way we are now. And 10 years ago, you could have said they're going to be drilling in frickin' Heatherwood, in Broomfield, and everywhere else. They're marching into Denver and DIA, okay? So we need to get a damn handle on it. Jared's talking about an equitable transition, okay? Jared made the point, you got to talk to folks, this top one, when you sit down with industry, and the legislature is going to hear from industry. And the folks who are pushing these bills are going to have to sit down with them. We do all use energy, we've heard that, but on the bottom, we all desire livable communities at the same time, right? So I want to start, I've got 12 points, I'll go through as fast as I can, but prioritizing local control, for me it's beautiful because I take issue a little bit with Matt, PUC model might work, reinventing the commission, but why not bring the power back closer to the people? Greeley passed the ban that was first litigated and overturned by the Court of Appeals. The people passed it and the city council passed it. 1992, 26 years ago, okay? You put the power in the hands of the people, we start chipping away and saying, no, you can't do it here. You can't do it in our best open spaces. You can't do it within city limits when it's an actual city, and you can't do it other places where it doesn't belong. Okay, once again, statewide setbacks and rules as a regulatory floor rather than a ceiling. That's going to help our governor and our legislature to keep our majorities. So we're going to do everything we can for Weld, and we're going to raise that ceiling everywhere else. I'm calling, so, once again, Chiropolos testified to the 2013 setbacks rulemaking, COGCC, and Jared, he talked about local control, and we're going to work with Jared and the legislature to make local control happen because I think it's very, very important. On setbacks, I'm just throwing out half-mile setbacks for our schools and hospitals, all right? Half mile, 2,640 feet, so it's pretty close to 2,500. It's more, it's the evacuation zone. All those fires we heard about, there's been 150 since 2005 if you update the study. You evacuate within a half mile, all right? Residential setbacks, I'm starting with a quarter mile, 1,320 feet. They're already doing it. Industry knows that you need these mega pads and the huge facilities, you need to be far from people. So we're building on what's already happening. People before profits. Martinez, I want to see what the ruling says, but this governor can rely on Martinez to say no. Stanley Lake, water supply, Rocky Flats, the Rulison of the Front Range, our state parks. Why are we even thinking about drilling in these places, right? Revenues and severance taxes is a big one. There's a lot of information. The bottom line is they're drilling on the cheap here. They're drawing in investment money because they're getting it for free. And we have left billions of dollars on the table that we will never get back. In the future, we're going to capture this money to fund the equitable transition, right? Okay, opportunity, forced pooling will chip away at that. Absolute, quote unquote, is not property right. Appointments and officials, no revolving door, put good people, let them do good things, implementing Martinez. Comprehensive planning, bonding and hearings, we already heard about, at least the hearings from Matt. Rulemakings are pending. I would suggest let's see what we get out of the commission and then see if we need to shop it around with the legislature. Other folks might differ. Enforcement, obviously really important. We've got more to do on wildlife. But I think the big message is we need to come together. United we stand, divided we fall. Those folks, Colorado Rising, God bless them, put 112 on the ballot, 1.1 million votes, 45%, 100,000 more votes than the Republican candidate for governor. Okay, so they're scared, and that doesn't get us at the table. That gets us in a position to transform what's happening in Colorado.
Holy cow. All right.
So the supervisor of the extraction oil and gas contractor at that Windsor fire that Dan showed, and I quote from an article, it could have been like an atomic bomb going off. So those setbacks that you have in there are nothing. I mean, look at all those permits. And when you talk about a 1,300-foot setback, what does that do for an atomic bomb? They said that they could have had every piece of glass in a car, house, anywhere within 5 miles break if they would have not had it shut down properly before the fire reached.
It's critical care facilities, it's like a floodplain, whatever it is, and I've worked on this on other land use issues. I hope every legislator in the caucus reads Dan Glick's great High Country News cover story, one-year resident, one-year community blows up. A colleague of mine got a 2014 fire in Ohio at a fracking site, 20 vehicles blew up, and there was noxious stuff burning into the air. So yeah, we can talk about the distances, we can agree on the need for aggressive, meaningful setbacks based on today's fracking technology.
So I have this concern with local control, and that is that I think most municipalities should not be bearing the burden of having all the technical expertise and the legal expertise to be regulating oil and gas on such a minute scale. Really, the state and the feds should be protecting us. They have to protect us because we can't afford it on a municipal.
My answer is land use and zoning. They do it for every other industry and economic activity in the state. They do it responsibly. They do it well. If industry doesn't like it, they can sue. If the citizens don't like it, they can sue. Okay, so the courts settle the disputes. And I think the beauty of local control beyond that is towns like Frederick, Dacono, Carbondale, Durango across the state are going to elect stronger leaders closer to the people. I don't care what party they are as long as they're standing up. But if you're a Dem, it's going to develop that Dem bench for Colorado for decades into the future, right? Phil?
I mean, it seems to me there's a logical conflict here. The state law says you have to protect public health and safety. It shouldn't be left up to the locals to disallow the protection of public health and safety. There has to be a state standard. Now, if the police powers of these local communities should be left to them. Preemption is wrong. They made a mistake. But there has to be a standard. You can't have it both ways. If you're going to have it both ways, it's going to be more conflict. It's going to be better conflict, but it's going to be more conflict. The state has a responsibility under the Constitution and under the Gas Conservation Act to protect the public health and safety. That is what our focus should be on. What does that constitute? I mean, that has to be the focus, Mike.
I'm gonna say two-pronged. I think local control gets at where things happen on the surface. I want to see how the Supreme Court comes out on Martinez, and then we figure out what we need to do and how. But I think we got 2 more speakers, so I'm gonna turn it over.
All right, and I think we're probably going to put some of these presentations up on a website so that people can access them. So I want to introduce the last 2 presenters. First is Margie Lewis, and she is an affected resident involved in a lawsuit in Triple Creek.
Hi, she said, I'm Margie Lewis, and I live in Greeley, and I live with 22 oil wells in my backyard. Extraction came in, and after they were turned down by a school, they came in to our neighborhood. And I'm going to talk about this from a very personal standpoint, which is health, because that has been one of the big effects on me, and I know a lot of you are concerned about health, and I can speak to it. They moved on site in the fall of 2016, and by January of 17, my asthma had flared, and it went on all year. I had 14 visits to my pulmonologist and to my internist over the course of the next year and a half. I had to change medications to control my asthma. I had, because I now had these more expensive medications. I was on prednisone, oral steroids, many times. And in the previous 10 years, I'd been on it once. Going into this process, my pulmonologist had always said I had mild, intermittent asthma. Coming out of this process, with all of the meds I'm on, I have, now that they've stopped drilling, finally gotten back to my pre-oil and gas influence in our neighborhood. My lung functions have returned, but it's on more meds and much more expensive meds. So yes, a lot of it I'm sure is the stress, but the fact that I have respiratory underpinnings created a lot of issues for me. Now, in January of 2018, it didn't get any better. And as a matter of fact, it got much, much worse. And we didn't know why. And Lowell will address that when he talks about what had actually happened, and we didn't know what had happened. But I'm happy to say that I am doing much better now, but going through that process is not a fun thing, and I really worry about it for children. I mean, the elderly, we've had a great life, but children don't even get a chance if they're brought up in that kind of a condition. So other things that happened with this, though, is that we had to keep the windows closed all year, summer, spring, when you would normally be able to open it and enjoy the air outside, you had to have your windows closed and run the air conditioner. Yeah, this sounds stupid, but from a woman's point of view, I had to dust multiple times a week. I would dust, and the next day there'd be a layer again because of just all the amount that was going into the air from the trucks. We can't use our deck anymore. Now we could use it, but we still hear the oil wells out there, and we see them, so it's nasty. I changed the filter on the furnace every month now instead of every 3 months. And it's getting better, but it was filthy for a long time. And as Dr. Stephanie Mallon had pointed out, she did some studies on economics, and she had one that she worked on when she was getting her PhD. And it showed how the values of houses go down when they're drilling. And it's massive. We don't know. We haven't tried to sell our house to see if that will come back. But the COGCC, they need to follow their own rules. And I'm with Matt that we need to have new people in there. I don't think that the people that are in there care. They're beholden to the oil and gas industry. And we would also like to see operators have some type of a weekly update, because you do not know what's going on behind those walls, as somebody said earlier. You have no clue what's going on behind the walls unless you fly a drone. So that's all I have.
No comment. So this is the story of Triple Creek in Greeley, Colorado. It's located in a pasture surrounded by residential neighborhoods. At the time it was announced, it was among the largest in the state. It was 22 wells on one pad, had laterals of over 2.5 miles. We were first introduced to the project at a neighborhood meeting in September of 2014, and at that time Triple Extraction informed us that they would be piping the minerals, the oil, off-site. The alternative was over 100,000 round trips of tanker trucks in and out of the site, hauling oil. About 14 months later, we had another neighborhood meeting that was called by the city of Greeley. Extraction reneged on their pipeline. The price of oil went down. They could no longer afford it. At this time, a group of the more active of the neighbors got together and formed a group called Neighbors Affected by Triple Creek. And we continued our preparations for our first hearing, which was with the City of Greeley's Planning Commission. We presented, City of Greeley presented, Extraction presented, and the Greeley Planning Commission rejected the project unanimously. Our understanding of that was that we were dealing with citizens just like us. Next, it went to the City Council for the City of Greeley. We lost 5-2. And then our quest now is with, at that time, goes to the COGCC, who issued an approval, but only after reluctantly accepting Triple Creek's designation as the first large urban LUMA, large urban mitigation area on the Front Range. That was supposed to give us some additional protections. However, Director at that time, Lepore, said that he did not have the authority to force Extraction to give us the pipeline that they had originally committed to, even though that was in direct violation of one of the underpinnings of the Large Urban Mitigation Act. So we decided, with the assistance of an attorney who shall remain nameless, but will always be considered a friend, that we needed to sue the Colorado Oil and Gas Conservation Commission, which we have done. It is still in appeal. So they know that we're still out there. I'm sure they're reminded on a weekly basis by their own attorneys. Extraction then moved on site in November of 16. They completed the project during December of 17. We had lost the battle, we had lost the war, we thought it was over. But then in May, I received notification that the CDPHE had permits that were out for public comment, and that these permits would set limits on the maximum volumes of maximum amounts of volatile organic compounds and hazardous air pollutants that can be released, and the maximum volume of natural gas that can be flared at Triple Creek. So I began the tedious process of reading and interviewing CDPHE personnel and to find out why these permits were involved. What did they mean? A part of the permitting incorporates the analysis of the natural gas which had been flared at Triple Creek since they started production in October of 16. Those values actually are on the COGCC's website under production tables, so it was relatively easy to find out what was flared and when. As it turns out, those values were quite extraordinary. During only the month of December 2017, 1 year ago, for a 1 month period, extraction flared almost 110 million cubic feet of natural gas at the Triple Creek site in Greeley alone. They wasted more natural gas in 1 month than is required to fuel New York City's largest power generating station for over 12 hours. And they released 61 tons of VOCs in the process into the surrounding air of our neighborhoods. I presented this to the COGCC at one of their Monday morning citizen bitch sessions and asked, how could this possibly be and how can we prevent it from happening again? Director Murphy approached me at the coffee break, to my surprise, and directed that Community Relations Manager Mike Leonard work with CDPHE to present a report to me explaining why it had happened. Throughout this time, I was also interviewing the CDPHE personnel and concerning those 4 permits, which were open for public comment. What I discovered was most disturbing. From October 11th of 2017, when the very first well began production and flowback began, until July 16th of this year, when those 4 permits were signed and approved, this is over a 9-month period that neither the COGCC nor the CDPHE had any regulatory authority over the emissions released by Triple Creek. The only agency with oversight and regulatory authority is the US EPA, and their only requirement was that the operator use emission control devices, those tanks that burn off the fuel, that they use them when flaring natural gas. That was it. So during this 9-month period at Triple Creek, the operator, in essence, could waste virtually any amount of natural gas and simply report it after the fact. And this practice of wasting extraordinary volumes of natural gas is by no means peculiar to Triple Creek or even to the Denver-Julesburg Basin. In fact, excuse me for just a moment, there's so much to cover here that it has to be tight.
Did you flip it?
Yeah. In fact, one newspaper, the Wall Street Journal, reports in August of this year that in Texas's Permian Basin, the largest oil and gas field in the United States, roughly, this is a quote, roughly $1 million worth of natural gas is burned away every day, going to waste, end quote, which is sufficient to supply the daily energy needs of states like New Hampshire or Montana. And worse yet, from a global perspective, quote, the flaring also produces greenhouse gas emissions equivalent to 2 million cars, end quote. In mid-September, I received the report from the COGCC. To summarize, the cause of Triple Creek's December flaring volumes was the unusual confluence of malfunctions and upset conditions on the DCP midstream sales lines, while other multiple wells were being brought into flowback. So extraction and other sites on the sales line basically had to flare the gas to prevent a catastrophe. In my conversations regarding the December problems at Triple Creek, I had been told frequently about the inadequacies of the natural gas sales lines in the Denver-Julesburg Basin. But in spite of this, new sites in suburban settings continue to be approved. It seems to me that these flares and releases are inevitable and that they will only worsen as long as the price of natural gas remains low, the gas handling infrastructure in the Denver-Julesburg station remains undersized, and we continue projects by Extraction and Crestone, who shoehorn their sites into tight urban areas and residential areas whose business models place children in immediately adjacent areas in harm's way as they are exposed to the hazards of this process. As always, my most grave concerns rest with the children at Bella Romero Middle School near adjacent to Eastern Greeley. They and the children growing up in mega developments in residential neighborhoods in Broomfield, Weld, Larimer, and Boulder counties and elsewhere on the Northern Front Range have only us to protect them, and I fear we are failing them. Thank you.
Okay, so yes.
Okay, the North Dakota Industrial Commission actually requires 85% of the gas that's flared in the state to be captured, right? They went to industry and they told them that there was a problem with flaring, and they said, we need to capture the gas. They require 85% to be flared. There's technology out there for when they drill a well that they can capture the methane instead of flaring it.
So, do you have a question for a particular
So,
person?
I don't know if...
I'm told that there is at least one prototype of a portable LNG plant, which can be moved to where the...
There's more than one prototype. Caterpillar has ownership in a company that does it, and they do it in North Dakota. And Colorado, I talked to the COGCC about it, and they said that they don't have any jurisdiction over that. That I'd have to talk to the CDHPE about that. But if North Dakota can require it, I mean, I don't see any reason why Colorado, when we have so many more people here and so many more wells going in right now, that we don't require methane capture, right? You're right. Right. Anybody know about that?
Part of this comes down to paper laws and standards and the difficulty in enforcing in real life conditions. I mean, I go back to the old Elvis Costello song, accidents will happen, but he's talking about the BP pipeline, but you're bringing in the mobile equipment. I mean, Hickenlooper and anybody else would say CDPHE has one of the stronger rules in the nation, the model for the BLM and the EPA standards, and I'm just repeating what they said, right? So, I mean, the challenge is on the ground in real life. And, you know, for our legislators, it's... Ken Wanslund said at one time, it's a dirty industry. You know, he just got frustrated. He said, what do you expect us to do? It's a dirty dang industry, and that's the bottom line. Yeah. As long as we're doing it, we're going to have these issues. We don't imagine we're going to BMP our way out of it. Right?
Well, and one of the problems is if our effective severance rate is that low, then it's effectively free for them to simply flare it off.
Yeah, that's right. But there's also something else going on in the statement that you made about the reasons why they were allowed to do this flaring, okay? The upset conditions, right, that they were reporting. This is very dangerous stuff here, okay? Windsor, the explosion at the Windsor facility, the COGCC allowed Extraction to do its own investigation, right? They came back with a report that said, well, there's all these potential causes, but we don't really know what the cause was. But here we've got all of these solutions that we're doing, right? They're covering up, they're masking these highly dangerous conditions at the same time that they're moving these operations into neighborhoods, right? So what's going on behind the permitting of flaring has a much darker and dangerous element to it, right?
Yes, sorry. Sarah.
I was just going to say, you know, like, if you think about it, all that's being flared into the air, no one is getting any revenue off of that at all, including people who are, you know, they stand by and protect and support this because they're mineral rights owners. But I think if they were more well-informed of, like, you're really getting screwed on this because your dollars are now up in the air.
Well, and the whole purpose behind having a conservation commission was to prevent waste, right? And the original, so what are we doing here with the rules? I mean, Sarah, did you have a question?
I'm wondering from the panel, what are your recommendations in terms of enforcement, where to get the money for it? Because it seems like if we increase the severance taxes in order to pay for enforcement, then enforcement is kind of by definition got a conflict of interest with itself. Those people who are enforcing are therefore paid by the industry indirectly. But how do you get money for enforcement for something this big?
Thanks for the question. Really important that we don't have severance tax pay for any enforcement. Severance tax is that tax that is, we're separating from the surface a mineral value that future generations will never see again. We need to put that into infrastructure, into building schools, into building, you know, better public transit, you know, light rail, you know, finally getting it to Longmont, which I would appreciate. A little plug there. But it never into enforcement. You know, for infrastructure type building materials, because we don't want schools to depend on it either. But there is a source right now that we had what? How many thousands of permits that were applied for in the last year? You know how much we get for those application fees? Zero. And that's something that we could easily address at the legislature. You know, make that something that where they're paying their own way. And I'm thinking $1,000 up, you know, per well to get us, you know, where we need to be as far as having the industry fund themselves, at least just for that. When you get into other issues around plugging and abandoning their mess when they pick up and leave, that's a whole different story, and that should be in bonding discussion, where the bonds are going to be sufficient enough to be able to pay for a plugging and abandoning of those, so it's not left to the taxpayers.
And if it ends up costing the oil and gas industry a lot more to do the work that they do, that's okay, because possibly fewer oil and gas plants will be built, which eases the transition away from fossil fuels. We have to get out of fossil fuels, and raising their charge, their expense, is part of that solution.
Dan, to clarify one thing, there's a lot of misunderstanding of what happens in the Supreme Court decision on Longmont and what the rights of citizens are compared to the rights of local government. And if Dan would, and if there's any lawyer up there that disagrees with that interpretation, I'd sure like to hear it. But Dan, would you, because a lot of people don't understand what their powers are in this state.
All right, I'm going to try to do this without, I can't do it without saying the term Dillon's rule, so I'll just get that out of the way, okay? But so this is what I call the preemption magic trick, and I've gone through this in presentations a lot, right? So in Longmont and Fort Collins, those were citizens' initiatives, right? And Broomfield and Lafayette, which got overruled as a result of the Supreme Court's decisions. But the Supreme Court never addressed the fact that citizens' initiatives, the right of initiative under Article 5 of the Colorado Constitution, has higher protections than the powers of local governments, right? Even home rule local governments, because of something called Dillon's rule. 1868 case in Iowa, Chief Judge of the Iowa Supreme Court, John Dillon, said, because the state creates the municipal corporation that is the city, gives it its powers, it can take them away. That's the sole basis for state preemption. It's not based in the Constitution, it's based on Dillon's rule, okay? And so all that the industry had to do in Longmont and Fort Collins was show that the ban or the moratorium was something other than a purely local law, that it impacted states' interests outside of Longmont or Fort Collins, Dillon's rule kicked in, the state could take away the right to pass legislation. But the Supreme Court never addressed the fact that this is citizens' legislation under Article 5. In my view, and I've spent about 3 years researching it and writing about preemption, there is no way that a citizens' initiative under Article 5 can be preempted by the state, by the COGCC, okay? That's why I helped the folks in Broomfield pass Amendment 301, okay? Because we're going to test out whether citizens have the right to pass legislation in or for their municipalities, which is directly the language of the Constitution, right? And so that's what part of what's at issue in Broomfield. But people have to understand that citizens' rights are more powerful than your local government's authority, right? And the U.S. Supreme Court has also said when the state is exercising its right of preemption over the cities because it creates them, gives them its powers, it can take them away, it cannot deny the rights of the citizens of that municipality. It can't get any clearer than that, right?
Okay, so stay tuned for the outcome in that Broomfield case to see what the Supreme Court has to say about that. Yeah.